Welcome to the lesson on the Universal Periodic Review of the United Nations Human Rights Council. As usual, all learning materials supporting the text can be found in the description below the video, listed in order of appearance. The United Nations, UN, has long pursued the protection of human rights as one of its core objectives. In 1946, the Economic and Social Council, ECOSOC, established the UN Commission on Human Rights, intended to be the principal global body responsible for this task. Although it was created with lofty ambitions, the UN Commission of Human Rights soon became the subject of widespread criticism. Its work was undermined by charges of politicization and the application of inconsistent standards, where certain countries were scrutinized while others, particularly powerful states, were overlooked. These shortcomings eroded its legitimacy, and by 2006 the Commission was replaced by the UN Human Rights Council. The Council inherited the experiences of the Commission but sought to operate with a different approach. One of its most significant innovations was the creation of the Universal Periodic Review, UPR. This mechanism was designed to address the failings of the Commission, particularly its politicized reputation, and to provide a fair, universal and structured system for evaluating the human rights record of all UN member states. Although the UN Human Rights Council has also faced criticism, the introduction of the UPR was widely hailed as an important reform. According to the Council, the UPR functions as a periodic mechanism whereby the human rights performance of each UN member state is reviewed in a cycle lasting 4.5 years. The working group responsible for this process convenes 3 two-week sessions annually, amounting to 14 sessions per cycle. Each state under review prepares a national report, which is supplemented by information gathered from non-governmental organizations, national human rights institutions, and other stakeholders. The review also takes into account the recommendations a state accepted during its previous cycle and any voluntary human rights undertakings it committed to implement. At present, 3 cycles have been completed. As Kathryn McNeilly suggests, this makes evaluation of the UPR's effectiveness especially timely. Christina Schurle argues that the central aim of the UPR is to reaffirm the indivisibility and interrelatedness of human rights, while providing a framework for constructive and equal dialogue among states, regardless of their relative power or influence. This framework is meant to enhance state participation, improve the quality of voluntary responses and recommendations, and ensure follow-up on implementation. The UPR has several notable strengths. Samir Rana argues that chief among them is universality, a sharp departure from the selective practices of the Human Rights Commission. Under the new system, every member state, whether powerful or weak, developed or developing, is subjected to review. This has helped foster a sense of equality and accountability. Another strength is the vast amount of information the UPR process generates, which includes state reports, NGO submissions, and contributions of national human rights institutions. As Emma Hickey notes, this information not only enriches the review itself, but also strengthens the broader UN human rights system, including its treaty bodies. The universality and inclusivity of the mechanism also countered the reluctance of powerful states to undergo scrutiny, thereby enhancing the system's legitimacy. Nevertheless, the UPR is not without weaknesses. According to Samir Rana, a first concern relates to the duration of reviews. In the first cycle, each review lasted only 3 hours, later extended to 3.5 hours. Given the large volume of information and complexity of issues involved, this brevity has drawn criticism for superficiality. Additionally, the UPR is often regarded as a political tool rather than a technical one. States sometimes form clusters based on geographic, cultural, or religious affinities, enabling them to shield each other from criticism. This politicization undermines the impartiality the mechanism was designed to ensure. Another major weakness, in Rana's view, is the absence of binding enforcement measures. While states must report on their progress, they are free to choose which recommendations to implement. This non-binding character has been criticized for encouraging empty rhetoric, as many governments focus more on their international image, particularly in Geneva sessions, than on meaningful domestic reforms. The lack of punitive sanctions further diminishes the system's effectiveness. Moreover, Richard Connor notes that instances of states refusing to cooperate highlight the enduring tension between state sovereignty and international human rights obligations. To this end, Makau, Mutua, Yvonne Terlingen, and Constance de la Vega have argued that while such resistance is inevitable, It undermines the universality and legitimacy of the UPR, rendering it less effective in compelling genuine change. In conclusion, the UPR has accomplished more than its immediate objectives. It has promoted universality, equality, and accountability by ensuring that all states, regardless of power, are subject to review. It has fostered cooperation and mutual understanding among states and strengthened the broader UN human rights framework. However, significant shortcomings remain, including its perceived superficiality, politicization, and lack of binding force. These weaknesses reflect structural issues rooted in sovereignty and global politics, which limit the possibility of fundamental reform. Compared with the discredited Human Rights Commission, the UPR represents a step forward, but its effectiveness remains constrained by broader political realities. Thank you for your interest in this topic. We hope that the lesson was helpful to you, and we are looking forward to seeing you again soon.